My name is Mbhalati, and I am with my colleague Tshepo Sebolai. We are both from the Financial Advisors and Intermediaries Department. The purpose of the webinar is to clarify the correct application of Section 13(1)(c) of the FAIS Act. We will also touch on the Juristic Representatives Fit and Proper Requirements in terms of Board Notice 194 of 2017. Just to kickstart, Tshepo, what is a Juristic Representative?
Thank you, Siku. A juristic representative, or JR, is a legal entity that has been appointed by the FSP to render financial services on behalf of that FSP.
Thanks, Tshepo. Now, since the juristic representative is a legal entity, how does it render financial services?
A JR must appoint representatives who will render financial services at the JR.
And are those representatives required to be appointed as representatives of the FSP?
Yes, those representatives are required to be appointed as representatives of the FSP. The FSP is required to maintain a rep register and keep that rep register up to date. For example, if there is a resignation at the JR, the rep register must be updated accordingly so that the rep can be removed. Likewise, if a new rep is appointed, he or she must be added onto the rep register.
Thanks, Tshepo. Now, can a juristic representative appoint representatives without consulting or informing the FSP?
No, because the representatives of the JR are representatives of the FSP, so there must be consultation between the JR and the FSP when representatives are appointed.
Okay. Now, are the representatives at the JR required to comply with the honesty, integrity, and good standing requirements?
Yes, the representatives must comply with the fit and proper requirements relating to honesty, integrity, and good standing. So before a representative is appointed, the FSP must conduct certain checks to establish whether the person is fit and proper to be appointed as a representative. Those checks must not only be conducted when a person is appointed. The checks must also be conducted on an ongoing basis after the appointment of the rep, because personal circumstances of representatives change. So the FSP must ensure that the representatives continue to comply with the fit and proper requirements relating to honesty, integrity, and good standing. And Section 9 of Board Notice 194 of 2017 contains incidents where a person will not be regarded as fit and proper. For example, the FSP must check whether a person was convicted of an offense of theft or fraud or forgery, or whether that the person breached a fiduciary duty. But for the FSP and the JR can refer to Section 9.
Thanks, Tshepo. The fit and proper requirements relating to competency in Chapter 3 of Board Notice 194 of 2017 applies to all FSPs, key individuals, and representatives. Now, what are the training and competency requirements applicable to the representatives?
The representatives are required to comply with the competence requirements relating to experience, qualification, regulatory examination, class of business training, product-specific training, and CPD. So when a representative is appointed, the FSP must ensure that the rep has the necessary experience. The rep has obtained a recognized qualification. They have completed the regulatory examination for representatives. They have completed class of business training and product specific training, and then they have also obtained the required minimum CPD hours. However, some of these competence requirements are not applicable to some of the reps. For example, let's say we are dealing with a rep that is only appointed to render financial services in respect of product subcategory 1.1 and 1.19. That representative will not be required to comply with the competence requirements relating to qualification, RE, class of business training, and CPD. Now, the information relating to qualifications, REs, class of business, and product specific training, and CPD must be provided to the, or rather submitted to the FSP, so that the FSP can record that information on the competence register. The JR must submit that information to the FSP to be recorded on the competence register.
Thanks, Tshepo. There are various requirements in relation to operational ability. Could you tell us about the applicable operational ability requirements of a juristic representative?
With regards to operational ability of a JR is required to appoint at least one key individual. That will depend on the size, obviously, of the FSP and the classes of business. The duty of that KI is to oversee and manage the rendering of financial services at the JR. Circumstances will determine whether the KI of the FSP is the same as the KI of the JR, because sometimes it may happen that due to factors such as a location, for example, where the FSP is located in one province and the JR is located in another province, you may find that the KI of the FSP is different from the KI of the JR. However, that does not mean that the KI of the FSP does not have the overall oversight on the activities of the JR. Another requirement is that the JR must have adequate financial resources to perform the activities for which it was appointed.
Thanks, Tshepo. Now, is there a requirement for a juristic representative to ensure compliance with the financial soundness?
Yes, a JR is required to comply with the financial soundness requirements that are applicable to the category of FSP that appointed the JR. For example, let's say we are dealing with a JR of a category 1 FSP that does not hold funds or collect premiums. Section 45.2 of Board Notice 194 of 2017 provides that the assets of the JR must at all times exceed its liabilities. Another requirement is that a JR must have adequate financial resources to ensure that liabilities are met as they fall due. Now, a question may arise as to how will the FSP ensure that a JR complies with the financial soundness requirements. And now, the JR must then submit its financial statements to the FSP so that the FSP can assess the JR's financial position and establish whether the JR complies with the financial soundness requirements. And also for those JRs that are required to submit liquidity forms to the FSPs, those liquidity forms must be submitted to the FSP within 45 days after every half year end. The FSP will use that liquidity form to establish whether the JR complies with the necessary financial soundness requirements.
Thanks, Tshepo. But can a juristic representative collect premiums into their own bank account instead of the FSP?
Before I answer your question, Siku, let me mention the reasons why Section 131C was inserted into the FAIS Act. Number one, it was to ensure that consumers of financial services know with whom they are contracting between the FSP and the JR. And number two, it was to remove any uncertainty as to whether the JR is acting on behalf of a principal or on its own behalf. And lastly, it was to prevent the undesirable business practice of renting a license. Now, coming back to your question, whether a JR can collect premiums. If the FSP is authorized to collect premiums, the premiums must be collected into the bank account of the FSP, because the insurer authorizes the FSP to collect premiums on behalf of that insurer. So the premiums must be deposited into the bank account of the FSP. Can also refer to Section 10 of the General Code of Conduct that deals with custody of funds. Even that the provisions of that section are very clear, because it provides that if an FSP, or rather if a provider holds funds, that provider must open a separate bank account which is designated for client funds. So even from that section, it's very clear that premiums must be collected into the bank account of the FSP.
Thanks, Tshepo. Is a juristic representative allowed to author their own marketing independently from the FSP?
No, the JR's marketing material must be clear that the JR is acting on behalf of the FSP. The issue relating to advertising and business documentation was addressed in guidance note on the interpretation and application of Section 131C. This guidance note was published by the then FSB. Now, let's say, with regards to business documentation, let's say a JR it's using a letterhead during the rendering of financial services. Now that letterhead, it must be clear that the JR is a juristic representative of XYZ Pty Limited, an authorized financial services provider with FSP number 123, for example. And again, let's say we are dealing with a JR that is operating a call center, that is rendering financial services through a call center. and the representatives are using the script. Now the script must also incorporate the fact that the JR is acting on behalf of the FSP. The representatives must make clients aware that the JR is acting on behalf of the FSP. With regards to marketing and advertising, if a JR has a website and they are using that website to advertise financial services that they are rendering on behalf of the FSP, that website must also state that the financial services advertised there are rendered on behalf of XYZ Pty Limited, an authorized financial services provider with FSP number 123. So that is clear. It's clear to the clients.
Thanks, Tshepo. And what about the disclosure document?
The same principle applies even to the disclosure document. The disclosure document must clearly state that the JR is acting on behalf of the FSP. The JR must not create an impression that it is acting on its own right.
Now, can a juristic representative contract in their own name with any third party?
I think here, before I answer your question, I must clarify that contracting here, we mean contracting in the context of financial services. Now, in terms of Section 13(1)(c) of the FAIS Act, a person may not contract in respect of financial services other than in the name of the FSP for which the person is a representative. Now, let me give you an example. Let's say a product supplier or insurer wants to enter into an intermediary agreement. Then the intermediary agreement must be entered into between the insurer and the FSP, because the FSP is the authorized entity. The insurer cannot enter into an agreement with the JR because the JR is not an authorized financial services provider. The agreement must be between the insurer and the FSP. Now, the issue of contracting was clarified in the FAIS Information Circular, Circular 4 of 2015, which was published by the then FSP. Now, in that circular, it was clarified that a representative cannot be a contracting party.
Thanks, Tshepo. So, is the juristic representative allowed to keep records of clients?
Yes, a JR may keep client records, but because the JR acts on behalf of the FSP, the JR has the obligation to ensure that the FSP has access to the records, and the records are kept safe from destruction and unauthorized access, meaning no one who's not supposed to access those records must access those records.
Thanks, Tshepo. In closing, do you have any closing remarks?
Yes, in closing, it is important that we emphasize the following. A JR acts on behalf of the FSP, and it is not an FSP in its own right. Number two, a JR must only render financial services in respect of financial products for which it is appointed. And lastly, a JR must comply with the policies and procedures of the FSP, because the JR is appointed by the FSP. There must not be a disconnect between the JR and the FSP, where now the JR is seen as operating on its own as an FSP. The JR is appointed by the FSP and must comply with the policies and procedures of the FSP. Thank you.
Thank you, Tshepo, and thank you to everyone who took their time to watch this webinar. We hope you found it very helpful. Thanks once more and goodbye.